Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Now then, there was plenty of movement on elections last week, and if you want to see a comprehensive list of authorities who have asked to postpone their elections and those who are going ahead, make sure to visit the news pages of the LLG website, where they are listed in full. This is a moving feast and lots of it happening all the time, and we will be sure to report to you on those developments. But as usual, there are plenty of other matters to keep us occupied, and we will kick off this edition by looking at new council AI guidance and policy, for which I believe we must turn to Wales. Dennis.
Helen, indeed we must. We go first to our Wales bulletin to see how a Welsh council has approached the development of guidance on its use of AI. The first example I've seen of this, Helen, Carmarthenshire County Council has adopted a new policy governing the use of generative AI tools such as ChatGPT and Copilot.
Yeah, it's very interesting. The local authority said that the policy has been created to ensure that any use of generative AI, I'm going to struggle with that word, Dennis, I think, within the council itself is, quote, ethical, secure, and compliant with legal and regulatory standards. Now, imagine that could be quite a challenge. It also said that the policy was designed to prevent automated biases, which some generative AI tools actually have been accused of exhibiting.
Indeed, and just as a reminder, generative AI refers to AI products which can actually create new content, such as text, images, audio, or code, based on patterns it has learned from large data sets. This includes many easily accessible programs, such as ChatGPT, we're familiar with that, Copilot, of course, Google's Gemini, and one called Bard. The policy document states that users may use generative AI tools for work-related tasks such as creating reports, emails, presentations, images, and customer service communications, as long as it is in line with the usage principles of the policy.
I'm interested about that Bard one, Dennis. I hadn't heard of that. I wonder if it says things like one doesn't know us. I
thought it might be something to do with Shakespeare, but that's just me being a bit
well,
cultural.
that's the point I'm trying to make badly. But the policy goes on. I'll return back to what we're looking at. It says, however, any information generated by generative AI must also be reviewed and edited for accuracy prior to use under the policy. The policy states, if a user has any doubt about the accuracy of information generated by Gen AI, they should not use it. I mean, this does seem quite common sense to me.
Indeed. And we've come across the problems before, haven't we, which we reported in the bulletin with lawyers relying on this for court proceedings and court documents.
Well, that's the point. I say it's common sense, and yet things have been happening. So, obviously there's a need to put it down in writing. The document, meanwhile, warns users that generative AI can never be assumed to be accurate, as it can produce hallucinations. We talked about these before, which are outputs that appear plausible, but are factually incorrect, misleading, or entirely, in fact, fabricated.
And it also rightly goes on to say that Gen AI can potentially produce inaccurate results, and therefore these outputs should be thoroughly verified for accuracy. That's what the policy says. Incorrect Gen AI outputs can have substantial political, legal, and financial consequences for the authority. Now, examples cited here include in 2021, a UK local authority faced legal challenges after relying on AI-generated data that incorrectly identified properties for council tax reassessment, leading to wrongful tax increases. Another public sector organisation used AI to screen job applicants, which inadvertently in the end introduced bias and led to discriminatory hiring practices, things that at all costs must be avoided.
Yeah, absolutely. And on data protection, and this is something we've touched on previously, the document says that users must not enter confidential and personal information into any public Gen AI tools, as they then become outside of the council's control, and information may therefore enter the public domain. And again, there's been concerns raised around that, especially in regards to child protection.
Mm-hmm.
And the policy lists examples of information that should not be entered into public Gen I tools. Again, it sounds obvious, but names, addresses, NI numbers, sensitive case details, even unpublished reports or draft policies,
Indeed.
which is interesting because it's a useful language tool. I can see people dropping draft policies in for rewording, but things like social care records, safeguarding reports, internal audit findings, and legal case notes.
Yes. And the guidance also said the tools must be used ethically, of course, and not to produce discriminatory, offensive, or inappropriate content. Any significant decisions taken that are assisted by generative AI should meanwhile be explainable and documented according to the documents. And I think that's an important point. Now, the policy was approved by the local authorities cabinet during a meeting on Monday, the 12th of January. And all individuals, including employees, casual workers, agency staff, elected members, volunteers, external consultants, or contractors who are granted access to digital facilities run by the council must, of course, agree to adhere to the policy. And this is what the document states. Helen, all of this is very interesting and will be of general interest to all of our members.
Very much so. I do wonder where the Information Commissioner sits, though, nevertheless, even though you've got this policy, if there is a major breach, I think there would need to be more than just the adoption of policy. I think there would need to be a lot of training. I think it probably at some point needs to be embedded into contracts, employments, and contractual contracts, all manner of things to try and safeguard the council as well as making
Indeed.
sure ultimately that it doesn't happen, which is the aim of it. It's not to protect oneself necessarily, but you always need an eye on that.
Yeah, agree entirely.
So I imagine we're going to see lots of councils following suit. They need to. So
Yes.
now let's move on to other news. Flagged in the LGA bulletin. If you work in children's services or advise those who do, you all know the sector has been bracing itself for another tough year, and the latest findings on illegal children's homes placements don't make for comfortable reading. A recent Public Accounts Committee report has revealed that around 800 vulnerable children in England have been placed in illegal care homes. Okay. That's an alarming statistic, and it's again raised serious questions about safety and oversight. And Councillor Amanda Hopgood, she's quoted as saying the system simply doesn't have the funding required to meet the level of need, and councils are urging government to help stop this practice.
And there is, however, some progress on this. The Children Commissioner, Dame Rachel de Souza, published new data showing that as of the 1st of September last year, the number of children in illegal placements had dropped to 669, down from 764 in the previous year. But that's where the good news ends, however. Costs remain staggeringly high, averaging £10,500 per week, with councils spending an eye-watering £353 million over the last 12 months on placements that not only fail to meet children's needs, but may actively put them at risk.
Yeah, and I think the report does paint a bleak picture. I think we have to say that. Because illegal placements actually include things like caravans, holiday rentals, and Airbnbs run by private companies with no inspection or scrutiny. And even more troubling, some of the children identified from last year were still living in illegal settings 12 months later, a stark indicator that safe and lawful alternatives haven't been found, or in some cases haven't been sufficiently sought. And that was in the report.
Yes, indeed. And individual stories illustrate this impact. One girl, whose name is Summer, was moved 4 times in 6 months before landing in an illegal home where staff spoke limited English, and she was left responsible for her own meals and finances. Another child, Amelia, has been moved between caravans, hotels, and rented holiday lets, none of which has improved her increasingly destructive behaviour.
Yeah.
Very
Yeah,
sad.
what it is indeed, isn't it? And while the forthcoming Children's Wellbeing and Schools Bill aims to give Ofsted new enforcement powers and create updated forms of lawful accommodation, these reforms, of course, aren't yet in force, and even then, fines may barely register with multi-million-pound providers.
Indeed. And the Commissioner's message, however, is clear. Unless the system invests in early intervention, therapeutic support, specialist foster carers, and more high quality children's homes, children will keep being failed. And as she says, these 669 children should be the system's bellwether. If we get it right for them, we stand a chance of getting it right for all children in care.
Yeah, absolutely, Dennis. Now then, it's been a long time since the four-woman Scottish case, and we are still none the wiser about what the government intends to do about same-sex spaces. But there has been a recent court case which explores the issue, Dennis.
Indeed, there has. And an employment tribunal judge has ruled that a group of nurses who complained about a trans colleague using single sex changing rooms at work suffered harassment. The judge found that the nurses' dignity was violated by the trust, their employers, and they encountered a hostile, intimidating, humiliating, and degrading environment at work.
Yeah, so the seven female nurses, and they work at Darlington Memorial Hospital, brought a claim against their employer, who was County Durham and Darlington NHS Foundation Trust. Now, this all stemmed from their objection to another nurse, named as Rose Henderson, a trans woman, being allowed to use the women's changing facilities.
Yes, and Judge Sweeney said, the Trust subjected the claimants to harassment related to sex and gender reassignment by permitting the claimant's biological male trans woman colleague to use the female changing room and requiring the claimants to share that changing room without providing suitable alternative facilities.
Yeah, and the ruling also said that the Trust subjected the nurses to harassment by not taking their concerns seriously. So in the report, it said that this included referring to the need for the claimants to be educated on trans rights and to broaden their mindset, the later provision of inadequate and unsuitable changing facilities for those who objected to sharing the female changing room with that colleague.
And Judge Sweeney went on, the above conduct had the effect of violating the dignity of the claimants and creating a hostile, intimidating, humiliating, and degrading environment for them. But here's an important point. The tribunal dismissed as not well founded complaints about Henderson's own conduct, saying that she did not behave improperly whilst using the changing room. I should emphasise here, Helen, this case is all about the things that the trust as an employer did wrong.
Yeah, absolutely. That's a very important point to make, Dennis. But it said that that regardless of that, it no way diminishes the very real and genuine perceptions of the claimants, all of whom were fearful of the risks, at the very least, to their dignity, bodily integrity, and privacy. Now, after the judgment, Bethany Hutchinson, the nurse who led the claim, said it was a victory for common sense. And she went on and said, today the tribunal has confirmed what we have said from the beginning, that requiring women to undress in front of men is not equality, it is a violation of our dignity. That's a direct quote.
Yeah. Now, ministers have said they will not be rushed into giving guidance on same-sex spaces, yet it is now 9 months since the Scottish case on this issue was decided.
Yeah.
And as you mentioned, we covered this case, the title For Women Scotland Limited against the Scottish ministers. We looked at this last year. And just as a reminder, the court found in a unanimous decision then that referring to the Equality Act 2010, the terms man, woman, and sex were always intended to refer to biological sex and not gender or gender identity.
Yeah. Well, the tribunal in this latest case also upheld the nurse's complaint of indirect sex discrimination, in that women were more likely than men to experience fear, distress, or humiliation if they were required to change in front of a member of the opposite sex. Interesting finding.
Mhm.
The panel ruled that the trust had breached health and safety regulations and, quote, had infringed the claimant's right to respect for private life under Article 8, of course, of the European Convention, excuse me, on Human Rights.
Now, to conclude, a spokesman for an organisation called Not in Our Name, a collective of women in support of the trans community, said, a key message being put out in relation to the outcome of this case is that it should be a lesson to organisations to listen to women. However, it is crucial to note that not all women feel trans people should be excluded from gendered spaces. I think this is a very important point, and they added, you can support women's rights and be inclusive of trans people. The ideas are not necessarily contradictory.
Well, that's incredibly insightful, isn't it? And really
It
important
is.
because what they don't need to be. And there are ways through this which are respectful for everybody.
Yeah, I think the
Um,
key here, Helen, is that there are messages for employers, and we
I think
really
that's
need
right.
that guidance soon.
Well, yes, actually, and it's the fact that we don't have it is obviously continuing to cause a lot of problems. Um,
Exactly.
and we don't actually even know when it's coming, do we?
No, we don't.
Well, let's turn our attention to planning news now. So those working in planning and development will know that the rules around varying planning permissions have been a persistent source of uncertainty. Now, two recent letters, one from the Minister of State for Housing and Planning, that's Matthew Pennycock, back in December, the 18th of December. Lots happened that day, if you remember, Dennis.
Yes.
And a letter in response from the Planning Inspectorate's outgoing, as it happens, Chief Executive Paul Morrison, show a notable attempt to bring clarity to a system under strain.
Yes, the minister's December letter sets out the government's position against the backdrop of a deeply challenging housing market. Construction costs, high interest rates, wider economic pressures, and the lingering effects of the pandemic have all hit delivery hard, with London experiencing particularly acute difficulties, something again we covered in a recent bulletin. Now, these pressures have contributed to a fall in demand for Section 106 related social and affordable housing, prompting the government to progress a broader policy package aimed at dealing with uncontracted Section 106 units and preventing the issue from recurring.
Well, within this context, Pennycook highlights the urgent need for mechanisms that support viability in the short term. Now, I think he states that the government recognises that in specific circumstances, modifying existing planning obligations may be necessary to keep housing delivery moving, including social and affordable homes. However, the minister is unambiguous about process. The proper statutory route for modifying or discharging obligations, he says, remains Section 106A, and local planning authorities are expected to adopt what he calls a pragmatic approach when dealing with requests to renegotiate.
And the Minister is equally clear that Section 73 applications should not become an informal shortcut for reopening fundamental viability issues. Attempts to reduce affordable housing through a Section 73 application will need robust justification, he says, and decision makers should give due weight to the harm that any reduction may cause.
Mm. Well, looking forward, much emphasis is placed on Section 73B, and that's been legislated for in the Levelling Up Regeneration Act 2023 and intended as a replacement for Section 73 for most post-permission variations. Now, I think it's fair to say that the government sees Section 73B as the main mechanism for dealing with legitimate changes over time, but explicitly not as a tool to reduce existing planning obligations, including affordable housing. Now, guidance on the respective use of Section 73B, 73, and 96A will accompany its implementation through secondary legislation.
And Paul Morrison's reply, published on the 15th of January this year, indeed welcomes this clarity. The Planning Inspectorate commits to supporting the transition to the new Section 73B regime and to applying future guidance consistently once issued. In the meantime, the Inspectorate will continue to operate under existing statutory frameworks, namely Section 106A and Section 73, mindful of the principles highlighted in the draft National Planning Policy Framework consultation.
Yeah. Well, Morrison also acknowledges the government's emphasis on scrutinising viability-based requests carefully and maintaining affordable housing commitments wherever possible. Consistent theme that. And his letter closes with a personal note of thanks as he prepares to leave the inspectorate, recognising the minister's support in ensuring PINS has the resources and clarity needed to deliver fair, timely, and transparent decisions.
For planning professionals, this correspondence, on the face of it, signals a renewed government push for consistency, rigour, and a more structured approach to post variations. At least, Helen, that's the intention.
Yeah, well, let's see. As always, let's move on. A subject of keen interest to me, and that of many of our listeners, Dennis, is that of scent provision. We've discussed it countless times on the podcast. Now, we know there's an intention by the government to provide a different way of meeting children's needs because it says it's looking at the entire system. But what we don't know is what that might actually look like. But I know you've pulled up some SEND tribunal figures, Dennis. Let's take a look at those.
Yes, these are interesting. The SEND jurisdiction of the first tier tribunal has faced unprecedented demand, registering 24,000 appeals during the year 2024 to 25 and disposing of 19,000 cases. And that's an increase of 34% over the previous year. All this according to the president of the Health, Education and Social Care Chamber. The figures from Judge Mark Sutherland Williams are contained in Lord Justice Dingerman's first annual report as Senior President of Tribunals.
Well, the HESC oversees 5 key jurisdictions. So these are mental health, special education needs and disability, disability discrimination in schools, care standards, and primary health lists. So, according to the report, across all HESC jurisdictions, remote and hybrid hearings have become, quote, standard practice, with SEND hearings defaulting to video with in-person options available.
Yes, and while acknowledging the unprecedented demand faced by the SEND jurisdiction, Judge Sutherland Williams noted that in 2024 to 25, 65% of appeals were still resolved within the 22-week target, and 95% of decisions were issued within 10 working days of hearings. And he attributed this to an increased focus on enhancing case management and forward planning, and listed the following innovations by the tribunal. And these include, and perhaps are of interest to other aspects of the judiciary and the courts process too. But first, judicial alternative dispute resolution was delivered by salaried and fee-paid judges. Hearings were held during school holidays. Enhanced case management was put in place for effective listing of appeals. There was a rollout of short-form decisions in line with guidance issued by the Senior President of Tribunals, and they introduced new practice guidance on what to expect at SEND and other hearings. And there was a new practice direction on how to prepare bundles for SEND cases and hearings.
Well, the report noted these initiatives enabled SEND jurisdiction to manage phase transfer appeals efficiently, enabling more phase transfer decisions to be made in time for school placements on the 1st of September 2025 than would otherwise have been possible, which can only be a good thing. Meanwhile, on the issue of transparency, Judge Sutherland Williams noted that HESC continues to improve public access to hearing information, adding that the publication of daily hearing lists in SEND, starting from September of last year, had marked a significant step forward in accessibility and openness. And Lord Justice Dingemans, am I pronouncing that correctly?
I think that's right.
Yeah, who started in the role of senior president of the tribunals in August of last year, so bedding in still, set out in the annual report his key aims for the year ahead, which include addressing backlogs, digitalisation, transparency, and openness.
And thanking his predecessor, Sir Keith Lindblom, who led the tribunal for 5 years, Lord Justice Dingerman said Sir Keith's commitment to improving equality, diversity and inclusion in the tribunals, and his dedication to pursue the aims of the one judiciary approach were exceptional. And he said he looks forward to continuing this very important work. I should mention the aim of one judiciary is to bring the courts and tribunals closer together to make better use of resources and to demonstrate that judges are part of a single judicial family. And it looks as though they've achieved that with these SEND hearings from the statistics from last year, Helen.
Yeah, well, hopefully they'll be just like the local government lawyer family then, Dennis,
Indeed.
and all will be well. Let's
Yeah.
see. And for our final item of this edition, if you work anywhere near information governance, and let's face it, we all do in local government, the Court of Appeal's recent decision in Buzzard Quashie and Chief Constable of Northamptonshire Police is definitely worth a strong cup of coffee and your full attention, because actually the ramifications could be quite serious. Now, writing for the local government lawyer, Matthew Simpson of 5 Essex Chambers pulls out the headline issues, and they're not pretty in this case.
Certainly are not. At its heart, this is a story about one woman's 4 year struggle, and it is indeed a struggle, to obtain body-worn video, known as BWV, from her 2021 arrest. From the moment a sergeant described the footage to her over the phone, Miss Buzzard Quashie knew that the video did exist, but getting it disclosed was another issue that turned out to be another matter entirely.
Yeah. So first came a subject access request, then an ICO complaint, which I should say the ICO upheld, directing Northamptonshire Police to sort out their handling of her request and disclose the BWV, quote, as soon as possible. Months passed, still no full disclosure, and convinced footage had been altered or deleted. Ms. Buzzard Quashie took the Chief Constable to court under the Data Protection Act, and the County Court agreed with her and ordered a complete BWV disclosure, or at the very least, a senior officer's explanation of what had happened to it, and the force did neither.
And cue now the contempt proceedings. A first attempt failed with His Honour Judge Jen finding, incorrectly as it turns out, that the Chief Constable couldn't be personally liable, that a penal notice was missing, and that there was no deliberate breach. But on appeal, everything changed.
Yeah, that's right, because shortly before the Court of Appeal hearing, the Chief Constable produced fresh statements admitting new BWV had been discovered. Files saved under the wrong occurrence numbers, found only because Ms. Buzzard Quashie's team had dug through audit logs. 5 additional video clips eventually surfaced, which it contradicted years of assurances, actually.
Yeah, faced with the undeniable, the Chief Constable conceded the appeal and apologised. The Court of Appeal didn't stop there, however. It clarified 3 big points on this. 1. Contempt doesn't require willful or intentional breach, just breach. 2. A penal notice isn't a prerequisite for a finding of contempt. 3. Chief Constables can be held liable as corporation sole for the acts and omissions of their officers and staff. And the judgment also underscores the weight courts give to ICO directions, the absolute necessity of robust data systems, and the risks of poor audit trails.
Yeah, well, robust data systems are going to become even more important when we have the Public Office Accountability Bill as well, because that's going to bring in some quite hard-hitting offences if people can't disclose their data on inquiries and investigations. But back to this case, in the end, the Chief Constable was fined £50,000, which is money coming straight out of the police budget. And as Simpson neatly concludes, the consequences of getting information governance wrong couldn't be clearer. For public authorities, this case isn't just a warning, it's an alarm bell. I'm interested about that penal notice decision at first instance, because that's surely pertains to the power of arrest as opposed to the finding of contempt. I'm no absolute expert in that area, Dennis, but I wouldn't have thought that you needed one at any time for a finding of contempt, surely, because
yes, that's normally where there's a further sanction, like imprisonment or something like that.
yeah.
I think the initial hearing, the judge at first instance, as has proven to be the case, got it all wrong on this. He got into a dreadful mess with this case.
Yeah. Well, it's an interesting case, and obviously, lawyers need to be mindful. I'm just thinking of a situation where the CEO might be dragged into court for contempt, and actually, that's been threatened before in all manner of cases.
Yes, I think yes, there's an underlying moral, isn't it? Because we've seen examples where the ICO has called out authorities, public bodies that haven't taken their obligations under the data and information legislation, taken it seriously. This case demonstrates it has to be taken seriously. There
Yeah,
are serious consequences.
yeah, and I can't imagine that Chief Constable was particularly pleased about all of that either. So, but a
Certainly not.
victory. Yeah, a victory in the end. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 3, available on the LLG website now. So it's goodbye from me.
And from me too. Bye bye now.